Well, yes, nullification of marriage is required because still lot of marriages take place due to fraud and various other reasons, like marry to avoid cheating or rape cases, marry to avoid other criminal cases, to hide affair, under pressure from family, to hide problems, child marriage, etc. People have lot of imagination to solve their problems by marriage. We've seen many innovative solutions by fake marriages. The basic difference between divorce and annulment is, while a divorce dissolves a marriage, an annulment renders the marriage null and void, that is as if the marriage did not take place at all, and that is a very big difference. Annulment is better and preferred than divorce because it deletes the marriage and declares a person unmarried. That means that there is no need to tell that you are divorcee. And we all know the difference this can make while finding a potential partner. It is at the option of the parties to continue with marriage or to annul marriage by decree of court. The available grounds for either spouse are: 1. Already married to someone else at the time of the marriage. 2. Too young to be married, or too young without required court or parental consent. 3. Under influence of drugs or alcohol at the time of the marriage. 4. Mentally incompetent at the time of the marriage. 5. Consent to the marriage was based on fraud or force. 6. Incapable physically, unable to have sexual intercourse, at the time of the marriage. 7. The marriage is prohibited by law due to the relationship between the parties. 8. Prisoners sentenced to a term of life imprisonment. 9. Concealed drug addiction, prior criminal record, or having a sexually transmitted disease. 10. The wife was pregnant with some other person at the time of marriage. Annulments are definitely rarer than divorces. Annulment can be granted when a marriage is either void or voidable. So what is void and voidable marriage? The void marriages are automatically annulled as they are prohibited by law. The voidable marriage is in which one party needs to seek annulment from court based on available grounds. Once annulment is granted by the court, the status of the parties goes back to what it was before the marriage, means they are declared unmarried. A marriage is automatically void and annulled when it is prohibited by law. Section 11 of Hindu Marriage Act, 1955 deals with bigamy. If either spouse was still legally married to another person at the time of the marriage, then the marriage is void and no formal annulment is necessary. Interfamily marriage. A marriage between an ancestor and a descendant, or between a brother and a sister, whether the relationship is by the half or the whole blood or by adoption. Marriage between close relatives. A marriage between an uncle and a niece, between an aunt and a nephew, or between first cousins, whether the relationship is by the half or the whole blood, except as to marriages permitted by the established customs. A voidable marriage is one where an annulment is not automatic and must be sought by one of the parties by approaching courts. The grounds are impotency, or lack of mental capacity, or underage of consent, fraud or force. So what are the rights of children, if any, from annulled marriages? Children, if any, from annulled marriage are legitimate. The court has the ability to establish rights and obligations related to the children from such marriages. For the difference, a divorce is usually much more complicated than an annulment. In court, the annulment procedure is similar to that of a standard divorce. To get an annulment, a person first needs to meet the residency requirements of the state that they live in, which is to establish jurisdiction. Similar to a divorce, marriage annulment case proceeds with the filing, petition, summons, and ancillary documents. Just like divorce, an annulment case can be initiated by either the husband or the wife. The grounds for annulment have to be stated in the annulment petition, just like divorce. Finally, when the declaration of nullity of marriage is made, court also decides the maintenance which has to be given to the opposite party. Annulling a marriage simply erases it from the records, as if it never took place. The result of marriage annulment is a decree that the marriage never existed, so it differs from decree of divorce. Annulment nullifies the marriage, returning the parties to their prior single status, that is, unmarried, which is big relief for many people. Nullity of marriage declares that there was no status of marriage between two persons. Null and void marriages have no legal status. They are against the law and hence they are not enforceable by law. It's a misconception that only short marriages can be annulled, hence note that the duration of the marriage is not important. It is correct that many times, annulments occurs very shortly after marriages, hence there is no need to divide assets or liabilities or custody of children produced by the marriage. In the case of a longer marriage that is annulled, the court will divide the property of the parties. For the Christians, there is separate marital law. Indian Christian Marriage Act, 1872 was enacted. And for their divorce or nullity of marriage, Indian Divorce Act, 1869 is applicable. According to this act, on the following grounds marriage can be declared null and void. Respondent was impotent at the time of marriage and at the time of institution of suit. Or bigamy, either of the party has living husband or wife at the time of marriage and that marriage is in force. Or marriage between the persons within the prohibited degree of consanguinity or affinity. Or either party was lunatic or idiot at the time of marriage. Special Marriage Act provides legal status and security to the inter-religious marriage performed according to the provisions of this act. Any person of any caste or religion may perform his or her marriage under Special Marriage Act. Under Section 24 of the Special Marriage Act, on the petition of either of the party, marriage can be declared null and void by the decree of nullity on following available grounds. Bigamy, either party has living spouse, incapable to give valid consent due to unsoundness of mind or mental illness, impotency, unfit to procreation of children. Parties are underaged. Parties are in relation of prohibited degree. Consent, marriage has not been consummated due to willful refusal of respondent. If wife was pregnant by some other person at the time of marriage, consent of either party was obtained by fraud or coercion. Hope this video will be helpful to someone.